Welcome everyone. Thank you for being here today. Hopefully you can see my screen. We're going to be talking today about heirs property, defining and supporting heirs property. And I'm happy to have with us a special guest, Ms. Deborah Neal. She's the president and she's also a consultant, community organizer, activist, advocate with Abide Well 360. And she will be joining in on the discussion about defining and supporting heirs property. Here's a bit about me. I've been with Legal Services Alabama since 2017, and I always tell people I do whatever legal services asks me to do, but my focus right now is on heirs property. I started off working with domestic violence and then move on to do housing cases, estate planning, a lot of probate work, and everything in between those two areas. Ms. Deborah Neal, as I stated, is here with us. She's a community organizer, advocate, and consultant. She's the president of Abide Well 360 LLC. She holds a Juris Doctor degree and served in private practice in the judiciary system for 19 years in Missouri. Since retiring to Alabama with her husband, she coordinates community forums, seminars, workshops, and trainings for diverse groups and individuals, including nonprofits, elected officials, and faith-based organizations. And Ms. Neal and myself, we've done a lot of good work together, and she does a lot of good work in the community. And so we are happy to have her here with us today. Our learning objectives today, we're going to define and identify heirs property, increase our knowledge of heirs property resolution tactics, and discuss and explore heirs property ripple effects. Some of you all may be familiar with Legal Services Alabama, some of you may not. So I just want to take a little bit of time to talk about who we are and what we do as Legal Services Alabama. We are a nonprofit civil law firm. We have 8 offices and a centralized call center where we all work together to fulfill Legal Services Alabama's mission, which is to serve low-income people by providing civil legal aid and promoting collaborations to find solutions to problems of poverty. We have offices around the state and we service all 67 counties. Within our offices, we have attorneys licensed in the state. We have support staff, we have paralegals, we have law clerks to help us, and we all work together to help low-income people resolve their legal problems. We provide extended representation on critical legal matters in judicial and administrative forums, counsel and advice, free consultations. We do a lot of community education and outreach about rights and responsibilities. We provide mediation services to keep disputes out of court, and we distribute and we develop legal self-help materials and forms, which you all may have received. So let's talk about heirs property. What is it? Heirs property is defined many different ways, but typically we're talking about real property that's been owned by someone at some point in time who died intestate, meaning without a last will and testament. And it's real property that's inherited by more than one heir of the deceased who have a fractional interest in the deceased property. And so that property becomes a property with encumbered title. There's no clear title to the land. You may have heard heirs property called by many different names, including family land, grandpa's land, estate land, tangled title, clouded title, heirs is property, heir property, all in the family, bunch of different names, bunch of different phrases to refer to the same concept of heirs property. Many people want to know who are the heirs, and the heirs are those persons, including the surviving spouse, who are entitled under the statutes of intestate succession to the property of the decedent, and the decedent is the person who's passed away. That's the deceased. And so when we look at Alabama Code Section 43-8-1, subsection 13, we see a list of potential heirs. Typically, we're going to start with the spouse, and we're going to look at issues of kids naturally, born children and those that have been legally adopted. We're also going to look at parents if there are no issue, there are no spouse, there's no spouse. We're going to look at siblings, grandparents, family related through grandparents, such as aunts and uncles, or aunts and uncles, as people may say, cousins. The law presumes that a decedent has a next of kin. And when we are defining heir, we are looking at a 5-day period. Any persons who have survived the decedent by 5 days is deemed to be an heir. Of course, going back to the category of folks I mentioned to you on a previous slide, if someone does not survive a decedent by 5 days, that person is deemed to have predeceased the decedent for the purposes that we're talking about here. Let's get into the ripple effects of heirs property. And for that, I want to give some examples of how heirs property looks in practice, what we see walking in our doors, what you all may see walking in your door. And so this is a more common case that I see as opposed to some of the smaller estates. But let's look at this family here where we're assuming it's 2021, and C9's family, and C9 is over here. Family wants to clear title to heirs property. In this hypothetical, we are assuming that, dad and mom is deceased. C1, which would be child 1, child 5, and child 9 are deceased. Everyone died without a last will and testament. Everyone died single, so they did not have a surviving spouse. So looking here, we will see that dad predeceased mom, and we're also assuming that they had a deed where mom was listed as a joint tenant with the right of survivorship, and she inherited the property when dad died. And the mom died in 2013. C1 through C9 would each split that 1/9 inch. They would have a 1/9 interest in the estate here. And then since it's 2021 and C9's kids are wanting to go ahead and clear title, now we're looking at another layer of heirs who get to stand in the shoes of those who have predeceased them, their parents. And we see this a lot. So we know that C1's kids will split that interest. They will have a 1/45 interest. C5 kids will split his or her interest and have a 1/27 interest. And C9 kids will have a 1/36 interest, each standing in the shoes of C9. One of the more clear-cut examples of heirs property would be like in this example, James McDonald. Old McDonald had a farm. He had 4 acres of land. He died single, and he had 4 kids, all living at the time that he passed away. He died intestate without a last will and testament. So each kid was stand to have a 25% share or 1/4 share in his estate. You all may have heard of the Allen family out in South Carolina. This is an example of an heirs property case that could be really challenging to resolve. This family purchased nearly 20 acres of land back in 1897 near the Hilton Head area. And as of 2021, there are over 100 known heirs. This is heirs property. It has not been developed. And trying to clear title to heirs property with that many heirs can take a long time, especially with the number of heirs expanding more and more each year as people transition from this world, as people are born into the world, as people marry, get divorced, all of that. And then you may have heard of the Bruce family out of California. They owned a beachfront resort. However, they were forced out of the area and they had to shut down and then the city seized their property. The family lost their portion, their fortune, excuse me. And it wasn't until 2021 when California Governor Newsom allowed them, the county, to give them that land back. When they got the land back, it was valued well over 1 million. It was several $1 million. But this is an example of another heirs property case. This family moving away, some of the decedents not knowing that they had an interest in this property. A lot of cases like this is why we're here today talking about heirs property, because there is a shift around the country of people wanting to locate heirs property, wanting to clear title to heirs property. They want to have a connection with the land that their family owned. When we talk about Section 43-8-40 in the Alabama Code, and we're talking about intestate estate in general, we know that any part of the estate of a decedent that's not effectively disposed of by his will passes to his heirs. And I wanted to give an illustration of that. I always like to put up this big chart so we can see the deceased in the middle, and we can see how the estate can descend down to the issue, to the child, to the grandchild, and so forth, or it could ascend up to the line where the parent is, go out to siblings. And if we don't have any of those, we're going up to the line where the grandparents are, up and out, up and out, up and out until we find an heir. And if we don't find an heir, then the estate is going to escheat to the state. So let's look a bit closer at this, Section 43-8-41. It talks about what happens if you die intestate under certain conditions. If you have children but no spouse, children will inherit everything. Spouse but no children or parents, a spouse will inherit everything. Let's read further down. The spouse and children who belong to you and that spouse. Spouse is going to inherit the first 50,000 of the estate plus half the balance of the intestate property. The children will inherit the remaining intestate property. I want us to look at this, and then I'm going to give a brief illustration of how this looks in practice with families, with what we see come in the door. As you see further down, if there are parents but no children or a spouse, the parents inherit everything. And then if there are siblings but no children, spouse, or parents, the siblings get to inherit everything. Sometimes we get people coming to our office where someone has died intestate, and they seem to believe that the kind of relationship they've had with the decedent matters more than the law. You know, like this is my favorite aunt, or this is my favorite aunt, so I should have her property, or I live in a property with her, I should have it. And many times we have to explain to folks, you know, there are laws in effect that govern how property transitions from one individual to another under the laws of intestate succession. So looking here, the share of heirs other than a surviving spouse. So we know that part of the intestate estate that's not passing to the surviving spouse, or the entire intestate estate, if there's no surviving spouse, will pass as follow to the kids. If they're of the same degree of kinship, they'll take equally, but of unequal degree, then those of more remote degree will take by representation. And you all saw that in the first chart that I showed you all, where we had C9's kids kind of taken by representation. And then here, if there's no surviving issue, to his parents or parents equally. And this is how that will look. We have dad who's deceased, and his kids will inherit because he had an issue. And then we have dad here, a kid passed away, one kid is living, but the child had issue. So the issue, assuming no spouse, will go there. And then a decedent passed away, no spouse, no kids. And so we have the parents who will have an interest in that estate. Under 43-842, subsection 3, if there is no surviving issue apparent to the issue of the parents or either of them by representation, and we see that here. Decedent, no parents, we have siblings who can have an interest in the estate. Here we don't have a surviving spouse, we don't have issue, and so that if you think back to the chart, that estate is going to ascend up to the line where the parents are and out to the siblings. And then here, I want to show you all this here, the share of heirs other than spouse. So if there's no surviving issue, a parent or issue of the parent, but the decedent is survived by one or more grandparents or issues of the grandparents, you're going to have where half of the estate passes to the paternal grandparents if both survive, or to the surviving paternal grandparent or the issue of the grandparents if both are deceased. And if they're not of the equal kinship, then they will take by remote representation. And then the other half will pass to the maternal relatives in the same manner. Of course, if you don't have any heirs on that paternal or maternal grandparent side, that estate will pass to the other side. And we see that here. It's the way, no spouse, no issue. Parents are deceased. One grandparent is deceased. We have heirs here on this side. And then, as we said before, if there is no taker under the provisions of this article, the intestate estate passes to the state of Alabama. And that's that chart again, so we will see it. Let's talk about how to spot heirs property. What we tend to look for when we have people come into our office is we're looking to find out, is the property owner deceased? How long has the property owner been deceased? And of course, what is our prospective client's relationship to the decedent? Did the property owner die intestate without a last will and testament? Does the deed remain in the deceased owner's name? How did the decedent own the property? Is there someone else listed there who has a future interest in the property? Is the property held in tenancy in common status? Is there an agreement and a record that governs partition? Did one or more co-tenant acquire title to property from a relative? And then we also look for any of the following. Does 20% or more of the interest in a property, does it rest in the hands of co-tenants who are related? Do we have 20% or more of the interest of the property held by an individual who acquired the title from a relative? And is there 20% or more of the co-tenants who have ownership in their property or interest in the property? Are they relatives? And that information that we're looking for, we're pulling it directly from the Alabama Uniform Partition of Heirs Property Act, or as you all may know, UPHPA, which is an act here in a state that really preserves the legacy of heirs property for heirs. It gives them the first right of refusal. It gives them the ability to purchase that property from other heirs, and it really helps to prevent investors or people outside of the family from just coming in, buying one co-tenant share of the property and forcing a sale of that property. So it has built-in protection and relief for heirs. Under this act, we're looking at real property that's held as tenancy in common that satisfies all of the following. And it's pretty much what I mentioned earlier. We don't have a binding, we don't have an agreement in a record that's binding on all of the co-tenants. We have one or more co-tenants who have acquired title to property from a relative, whether that relative is living or deceased. And then we have any of the following: 20% of the interest owned by co-tenants who are relatives, 20% or more interest held by individual who acquired title from a relative, whether living or deceased, or 20% or more of the co-tenants are relatives. As far as how this works, the law is going to give notice. The court is going to give notice to those heirs and give them an opportunity to get some sort of relief before the property is partitioned. And so the co-tenants must be notified of the request and informed that each co-tenant not requesting a sale has 45 days to purchase the interest of the petitioning co-tenants. And then there's a requirement that the property itself or fair market value multiplied by the petitioning co-tenant's fractional interest ownership of the entire parcel. And then the court is going to provide the purchasing co-tenants at least 60 days to provide the required funds for the court. This mechanism prevents one heir from trying to force a sale of the property and trying to sell the property below fair market value so as to cheat the other co-tenants out of their proper interest in the property. The UPHPA is also interesting because it really looks at not just the fair market value, not the sale of the property, not just the division of the property, but it also looks at the impact partitioning this property could have on the heirs. And so the court is going to weigh the practicability of division. Is it practical to divide up property? We're looking at one acre. It's probably not practical to divide that, partition that amongst 10 heirs. If we're looking at 80 acres, depending on the improvements that's on the land, that's more practical, right? The court is going to weigh the duration of time that the parcel of land has existed within the family, any sentimental attachments that the heirs may have, how land is being used, and whether the cessation of that use would cause harm to the co-tenants or a co-tenant, the degree to which co-tenants have contributed their pro rata share of associated expenses with land ownership. And when the court is weighing these factors, the court is looking at the totality of the factors, the weight of it, and it's not giving a sole weight to any single element so as to make that element the positive of the outcome of the case. So we're talking about heirs property. We're defining what it is. We're talking about heirs. We're talking about intestate succession. And sometimes people say, well, what is the problem with heirs property? Is it really a big problem? It is a big problem. Problems are land loss, tax sales, blight property, land disputes, heir location problems. You know, I've had cases where some of the heirs are here, and then we have heirs who live overseas and just trying to get in contact with those heirs, or you have family members who've gone missing, heirs don't know where they are. So it can be a very complex process to try to locate heirs, and the many heirs have challenges getting funding for municipal, state, and federal grants, which will allow them to improve the property. But I know Ms. Neal has done a lot of work in this area, and I want to turn to her to talk to us about, you know, what got her involved in this work, why the work with heirs property, the impact community outreach has on heirs property and in the neighborhood. Would you, Ms. Neal, can you unmute yourself and come on?
Yes, can you hear me okay?
Yes, absolutely.
Thank you. Hello, everyone. First of all, it's an honor to be here to talk to you about this work. I moved here to Alabama and was semi-retired and needed something to do. And so I started going to public meetings and I met a county commissioner here in Montgomery, and he took me on a tour of his district on the west side of Montgomery. And I thought I was riding through a third world country. There were a lot of boarded up homes, a significant amount of blight. And so I started doing some research, and I learned that in low wealth communities or communities of color, minority ethnic communities, a lot of boarded up homes are heirs property. In fact, almost 70% of boarded up homes, vacant homes, and particularly in communities of color or low wealth individuals, are heirs property. And so I started doing some research, and I came across an excellent resource called the Georgia Heir Property Law Center. And I saw where they host community outreach events to educate people about how to avoid heirs property. And they also provided legal support and representation to individuals who have problems with heirs property. So I thought it would be a good idea if we did that here in Montgomery. And so we started hosting these outreach seminars in partnership with Legal Services Alabama, and elected officials also supported this because they have a vested interest in trying to improve their districts and in their communities. And heirs property, it really does impact all levels of a community. One of the major things, major areas of concern about heirs property is loss of generational wealth. So I have attended neighborhood meetings, and in one particular neighborhood, there are about 200 homeowners, and in that area, at least 20% of the homes in the area were heirs property, blighted, vacant, abandoned property. The residents talked about the impact of having those properties. One of them was that it devalued their own property. And another thing was they saw an increase in crime. Whenever someone abandoned a home and there was no one taking care of it, blight increased. And so it attracted undesirable elements into the community. And some of the residents even talked about young people hanging around, causing problems in the area, and had to get the law enforcement involved. And so when I talked to one particular resident, she described a situation that was heart-wrenching. She said that she sat on her porch often, if the weather permitted, and she would visit with a neighbor across the street from her. And she said that this neighbor had a son who was in a nursing home. And then the mother, the owner of the home, became ill and she passed away. No one moved into the house after several years. It became blighted. People started going onto the property trespassing. And then one day she was awakened by a loud noise, and she saw a wrecking ball start knocking this house down. And she said she could see her neighbors' Sunday best hats and Sunday clothes flying all over her grass. And said, I thought, well, that had to be some heir property. We all have some next of kin somewhere. How do communities really address this to avoid this? And here's a loss of possibly generational wealth, because I understood that at one time this was a very nice home, one of the nicer homes on the block. And so when you have cloudy titles, and we all know about cloud over a title, it hinders a lot of positive things that can go on into a neighborhood or community. For example, local, state, and federal governments are hindered from providing disaster relief or funding for rehab, particularly in emergencies like a tornado. We recently had one here in Montgomery, and we did an heir property event June 3rd, and many of the residents attended that had heirs property, and they could not get any relief from the city. And there's been ongoing fundraising because people were displaced from their homes because they didn't have clear titles. Another problem with heirs property is that you cannot get homeowners insurance. If you have a mother that lives in a home and she passes away, let's say the house is paid for, and you have an adult child living in that home, if the mom did not have an estate plan or pass that house and title over to her child, then the child has difficulty getting homeowners insurance, and she has to do something about that. And so in these events, these forums, we educate people about these types of issues. And we did an excellent, overwhelming response about how people are really appreciative of having this information because so many of them have similar problems. The other thing is refinancing is unavailable. The other huge problem in these neighborhoods is predatory investing. And what that is you have investors without any local interest in improving the neighborhood that are speculating. And they're buying these properties sometimes at tax sales. And they sit there and they're just blighted properties, continually devaluing the surrounding homes value. The only other thing I really want to talk about is the complexity of dealing with heirs. One of the things that I know, having had family issues with heirs property, is that heirs really cross multiple generations, and they can be in multiple states, and even some can be outside the country. I have seen that. And so one of the important part of, I think, an attorney's role is to collaborate with Legal Services Alabama and title companies to try to identify heirs so that everyone can be placed on notice of their interest in this property. So there can be some resolution to this. And so I really appreciate having the opportunity to have elected officials wanting to have these forums. And if you look across the country, a number of states and communities are addressing this dilemma that we have in our communities. And so it's excellent work. I consider it social justice, a social justice issue. And it brings great satisfaction to bring some resolution to families, particularly who have a family home, has been in their family for some generations, and they really need a remedy to try to get some clear titles. And so I hope that this is helpful to you, and I'm happy that you're interested in being in this space because it's excellent, excellent, gratifying work.
Excellent. Thank you, Ms. Neal. And like I mentioned before, Ms. Neal has been very instrumental in helping us get around the state to bring awareness to the communities, various communities about heirs property. And we look forward to going to Tuskegee soon into some of the surrounding areas. Because we do have a lot of attorneys here on the line, I do want to talk about, how attorneys and even volunteer law students can get involved to help curb the ripple effects of heirs property. One of the things that you can do to get involved is to contact Legal Services Alabama, maybe consider becoming a private attorney with Legal Services Alabama. We have our private attorney involvement program, and it will be helpful because these cases are very complex. So you may not want to take the entire case, but you may want to help. And so there could be an opportunity to do some unbundling of services where you perform title abstract work, where you can help determine whether heirs property is an issue, help with a drawing of affidavits of heirship, providing mediation services, and assisting in other ways. There is a big push around the country to help curb the effects of heirs property. And many of you all may have seen the recent article that the American Bar Association released about heirs property clinics at law schools across the country. These clinics are being established at various law schools. I know FAMU, Florida Agricultural Mechanical University in Orlando, they have a law clinic. There's a law clinic here here in Alabama. There's also going to be one at Tuskegee University. They will have a law clinic soon devoted towards heirs property. And so we can work hand in hand with the law students to address this issue. Also may want to look at establishing a land trust or establishing an LLC, helping clients draft estate planning instruments to curb further fractionalization of the land. One of the things that we do when we have a client to come in with an heirs property issue is we assess the client's goals, just as you all may do a need assessment on any client, or for any legal issue. We want to know, does that client really want to stop the fractionalization process through the execution of a will? Does the client, prospective client, want to maintain the property in the family? Sometimes you may have folks who seek services and they just want to sell the property, or the heirs may not be in agreement, and that can be a dicey issue. We want to know if the prospective client is wanting to consolidate ownership into one person's name. That helps let us know that, maybe we can go the route of doing an affidavit of heirship and get quick claim deeds in place. We want to know, does the client want to obtain marketable title? And does the client wish to apply for agricultural loans or disaster relief assistance? There are organizations available who will have loans available for farmland, people who have heirs property. And so we can send them in that direction as well, and have funding or seek funding to assist with disaster relief. With mediation, this is a great area where you can help. Oftentimes, there are tenants in common who have no sentimental value to the land in question. In these cases, especially where there's a tenancy in common arrangement, mediation can be very desirable. It can be, as you know, a money-saving tactic to go into court. And so there are nonprofits such as the Federation of Southern Cooperative and the Land Assistance Fund that devote a lot of time to mediating these types of disputes. Sometimes that mediation is geared towards farmland owners, and so attorneys who are mediators who are willing to help mediate some of these cases that may just involve a handful of heirs, a handful of acres. That could be a great way to get involved with heirs property cases. And then clearing title to property, you all can get involved by helping to locate recorded deeds. You can get involved with, and you not believe, when we go to these outreaches, a lot of people don't know who their family members are. So even, and this may be for some of the interns who are looking at this webinar, or maybe some of the attorneys who want to get involved, but maybe not take on a whole case, just helping a family construct a family tree. That can be very, very, very helpful. And then also researching the historical data that we will need to move forward with clearing title to real property. And then thinking about long-term preservation of heirs property, creating a LLC, creating a land trust, which I understand in Birmingham, they're pretty big on doing a land trust, and then ratifying a tenancy in common agreement where we get the tenants in common to sign an agreement and then act pursuant to that agreement. Of course, we want to encourage people to create a last will and testament, because the last will and testament could be a way, although it's not a cure-all, but it could be a way to stop the fractionalization of heirs property. We always want to make sure when we're doing the will that we don't create heirs property in the will, as you all know. And this is critical when we're making the last will and testament, that we have, or the client knows to put the property in such a way whereas we don't create heirs property, and we don't leave it as tenancy in common unless there's a reason for that, and maybe we make it an indestructible joint tenancy with right of survivorship, or we just put it as joint tenancy with right of survivorship. It really just depends on the client's goals. And then another thing we can do to help is to draft affidavits of heirships. And this is just an affidavit where we're going to memorialize everything that's really happened from the decedent's death. For instance, the decedent passed away, was survived by X number of survivors. The decedent died intestate. The decedent owned this real property in question. There's not been any active probate proceedings. There haven't been any past probate proceedings. And this is a list of the known heirs who have a right to the property. And then we want to get to disinterested third parties who will be willing to sign the affidavit, to sign it in front of a notary. And we want to get that affidavit of heirship recorded in the office of the probate court where the decedent resided or where the property in question exists. And then after that, we can move forward with anything else we decide to do. If we're going to consolidate ownership of the property into one heir or a couple. So those are some ways that you all can get involved with heirs property. We've covered, we've defined heirs property. We've talked about how to spot it. We discussed the issues related to heirs property. We've talked about the attention heirs property has received around the country, and we've talked about some things that we can do as attorneys, as law students, as volunteers, community advocates and activists, what we can do to help curb this issue. And so I'm going to open the floor up for questions and discussion.
Start reading off some of the questions that have come in. The first one is there a requirement that related co-tenants be within a certain degree of relationship for the AU-PHPA to apply, or can related co-tenants be within any degree of relationship?
That's a great question. And so the UPHPA really says that they are co-tenants, and it doesn't define the degree of relationship. And so if they have an interest in the property, they are rightful heir to the property, and their degree doesn't matter that much, as long as they may be taken by a remote representation, and that's fine. One heir doesn't have superior rights to the other because of that. They may have a larger interest, but they would still have comparable rights when it comes to the UPHPA as far as having first right of refusal. So.
Next question was, what do you do about relatives that have liens against them? Is the only way to divide it through filing an estate to clear the liens? This person says, I have a family now that will all sign consent deeds so they could deed the 8 parcels according to their wishes, but their concern is that one relative has liens against them. From what they're telling this person, the mom has no bills to worry about.
So we have one heir who has an interest in the property, but that person has liens against them.
That's what the question seems like it's worded like. Maybe they've got judgments against them against one of the heirs.
Yeah. Okay. So repeat that question for me, the first part of it, Holly.
Sure. It says, what do you do about relatives that have liens against them? Is the only way to divide it through filing an estate to clear the liens? They have a family that will sign consent deeds so they could deed the 8 parcels according to the wishes, but one of those relatives has liens against them.
One way to do that could be to make it an indestructible joint tenancy with right of survivorship, so you don't have a situation where that person's liens could encumber the property. Or you could get those liens resolved first. And really, it goes back to assessing the goals of the family. The person who has the liens, are they willing to, just have a future interest in the property? Are they willing to allow the other heirs to have the property? It really just depends. I'm guessing there's more to that than just the liens.
And we can always drop your email in the chat if people want to reach out to you with more general
Please
questions.
do. Absolutely.
Next question was about notice, and this is a fun one in 2023. Can notice be given to heirs through publication, and if so, where is the notice published?
Yeah, so we want to put notice in a newspaper where the property is located and where the court action is going on. And to be, just so you don't have any issues, I would try to be as thorough as possible. And if you know an heir is living in a certain county, maybe that heir is living in Mississippi, somewhere in Mississippi, it wouldn't hurt to put notice in the newspaper there where you know that heir in the county where you know that heir is living.
Yeah, I say it's fascinating because, you know, a lot of Alabama's large print newspapers have gone out of publication. Like I'm here in Huntsville. The Huntsville Times is no longer a print paper, so it doesn't qualify as a newspaper of general circulation in the county where the property is located. And that's become an issue for our bar, that you run it in a what amounts to a newsletter that no one has ever heard of, because that is now the closest thing we have. So I wondered how the legislature is going to tackle that, which is why I said it was a fascinating question.
Yeah, luckily in Mobile we still have print newspapers, and so even though they do put the notices online, they still have they still have print versions too.
Yeah, it's fascinating as more print papers, particularly in rural areas, start to go out of business. Where in the world we can start publishing these things has been really interesting. The next question is, if someone makes improvements upon heir property without the permission of the heirs, can the person file a claim against the estate for the improvements?
They can do that.
Next question, are there any plans to expand these initiatives in the Black Belt, particularly in Lowndes County?
Yes, and I'm glad you asked that question, because I do want to talk a bit about our heirs property unit that we have here at Legal Services Alabama. It's brand new, and we do concentrate on the Black Belt area, and we also go around the state. We were in Selma a couple of months ago. I believe it was May. We've done so much in such a short period of time, so the time really does escape me, but it was just last month, even though it seems like it was 6 months ago. But we were there in Selma. We do plan to get to Lowndes County and some of the other areas in the Black Belt. The goal is to really hit that area hard and help people clear title to land. And we do have attorneys around the state, so we can cover the entire state. And we do have paralegals, and we do get calls from around the state. So just because you may see my information that says Mobile, please call to Legal Services Alabama. And as far as our income guidelines for those cases, we're taking up to 200% of the federal poverty level. So please call us. And if for some reason you have someone who comes to you with the heirs property case and they can't pay you, for the attorneys that are on the line that can't pay you, maybe they have a relative or an heir who has an interest in the property who does meet our income guidelines. You can send that person over to us, and we can help them through the individual who does meet our income guidelines. So please keep us in mind.
Absolutely. This is a statewide program. Even though Valynda is Superwoman and has figured out how to be in all 67 counties at once, we do have offices around the state and can do this around the state. I would also be remiss if I didn't mention that this is a great opportunity for pro bono. If it is something that you want to get involved in, people are always hesitant to take on a whole package of a case. You don't have to do that to help us with pro bono in these. In fact, if you know that your paralegal makes that trek to the courthouse to check property records every Wednesday morning to do a title search, and you'd be willing to give us 20 minutes of their time to run a property search in some of these rural counties where we would have to physically send someone to check probate, that's a great chance for pro bono that costs you 5 minutes of your time to have someone check a title for us. If that's something you'd be willing to offer pro bono, that's something that we would love to partner with you with. We are not saying, although we'd love it if you came in and took a 20-hour case for free, even if you can just give us a paralegal that can check probate in a county that we can't check digitally, that's a huge help. It means I don't have to send an attorney over to Kanika County or over to some other county to go pull a record. That's part of how we help people around the state, and it's a great opportunity.
Yes, and we do have a lot of cases coming from the rural areas, and you know, we can benefit from having attorneys and their staff who want to do some of this unbundling of services. It'll be very helpful. In Mobile, we have a very good probate court website where we can do all of the stuff, the title searches, and look at the cases. For some of the rural areas, they don't have that infrastructure built in, and so it will be a great opportunity for you all to get involved if you want to be involved with the heirs property work that we're doing here in the state.
And again, that's just a 5-minute opportunity. If you know that you or your paralegal or your assistant is at the courthouse anyway, and they're willing to say, hey, I check every week, send me one if you got it, that would be amazing for us. Let's see. How do you help someone who has lived in the heir property and paid taxes for 7 years and is trying to qualify for a federal grant to help repair the home?
Great question. It really depends on some of the other facts of that case. The person who's living in the home, are they really an heir to that property? You'd not believe it, but we've had people who have lived in the property and they're not a rightful heir to that property. And in those cases, the true heirs, they may be unaware of it, and so we may not want to touch that. We may not want to open Pandora's box because all is well. If they are an heir and all of the heirs are deceased, it really depends. You know, we can probate that estate. We can do affidavits of heirship to clear title to that property. We can bring a quiet title action to clear title to that property. It really depends on the facts of that case. But there are ways to clear title to the property that way, various ways actually.
Okay, the next two are kind of the same question, so I'm going to ask them together. Are heirs determined under the paternity laws when a child is born to unmarried parents? For example, the child stands to inherit the property because their parent has passed away. And the one right below it kind of feeds into that and says, have you seen any use of DNA studies in establishing family trees?
Yes. And Deborah, feel free to chime in if you want to. I'm not trying to hog all of the questions.
You're doing good.
Yes, I have seen DNA used to establish the family tree, and it's not as uncommon as you would think. Oftentimes, you know, we get these families who come in and there is an outside child somewhere. There's an outside child somewhere, and so there have been situations where people have used DNA to establish paternity, to assert their rights and interests in heirs property. As far as the is the paternity established for the child? Go back to that question for me, Holly.
It may have cleared it out when I clicked on it, but that was the question is, you know, if the child was born when the parties were unmarried and now the father has passed, those kinds of issues.
Right, that child is still going to have a right, you know, a right to that estate. Just because the parents were unmarried, that doesn't vitiate the child's rights to the estate.
Husband and wife, husband dies, mortgage is in the husband's name, but the widow would like to keep the house. Will she need to refinance or can she assume the mortgage?
It depends. It depends. First thing would be, you know, well, one thing would be that we want to look at the deed. We want to know what's on the mortgage. She would need to contact the mortgage company, and oftentimes the mortgage company is going to want something from the court that will give her authority to contact them. and that could be open up an estate, of administration if there's no will, or letters of testamentary to will, and negotiate with the mortgage company to see if they will allow her to assume that mortgage.
A pending quiet title action to clear title to heir property, a guardian ad litem was appointed to represent the unknown heirs. Since filing, all of the known heirs have deeded their interest to my client. No other heirs have been identified by the guardian ad litem. Will my client end up being able to get clear title to the property?
Repeat that again, the first part.
Sure.
The
They have
sound went out.
a quiet title action to clear the title to heir property. A GAL was appointed to represent any unknown heirs. Since the filing of the quiet title, all of the known heirs have deeded their interest to this person's client, and no unknown heirs, no other heirs have been identified by the GAL. Will their client be able to end up getting clear title to the property?
It's possible. It's possible that your client could end up getting title to the property sometimes at the 11th hour. These unknown heirs show up, and I've seen this happen in the case. So I say it's possible that your client could, but until you all have that final court appearance and GL gives a report to the court and says, no, I haven't been able to find any additional heirs, no one has showed up in the case. Until that happens and the judge issues an order, then there's some chance that your client may not get the title to the property. However, if none of that happens and there's no opposition, then yes, it's possible your client could.
Okay. We're getting to 12:59, so we'll go through one more question and then kind of do the wrap up. What can heirs do if they suspect that another heir knows of a will that the deceased had, but no initiative has been made to probate the will?
It's a great question. So under our laws, you know, that you can actually open up that estate, go ahead and probate that estate as a lost will. You can do that, and then our law has provisions in it that states if someone is in possession of that will, they must produce it. So if your client knows of someone who has the will and they're just hiding it or not doing it, you can raise that issue with the probate court and have them served, have the court direct them to produce that will.
And with that, we are so grateful that you came. Thank you for joining us at Legal Services as we work hard to keep these issues where ultimately our goal is to keep deserving families in their homes and allow that generational wealth to belong with the families that earned it and worked for it. If you have any other questions, we are always happy to talk. And thank you again for joining us today.
And so we also want to thank Ms. Neal.
Oh, you're welcome. It's my.
Thank you so much. Excellent job. And thank you, Holly, for navigating this for us.
Thank y'all so much. It was a joy to have you, Ms. Neal. Don't be a stranger. And thank you, Valynda. You do magic. And we are going to now close out the webinar.
All right. Great job.